Okay, well, let's get started. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Thank you all for joining us today. Today's topic is about social media and how to navigate the pros and cons and pitfalls of the platforms. So with us, we have Ian Roberts and Harmony Taylor. They're going to lead us through the discussion. Before we get started, mention that we are recording today's session and we do post these on the camsmgt.com website. You can find them on the board members resources section. Click on webinars, and we do have a lot of great content on the website for you all to view and send other board members too. So we do enjoy hosting these sessions, and we always do appreciate your feedback. So at the end of the session, we will be sending out a survey. So if you have other ideas and topics that you'd like to hear, we certainly welcome y'all's feedback. For questions, please use the Q&A feature located at the bottom of the Zoom icon, and you can ask those questions throughout, and we will answer those at the end of the session today. So again, thank you, Harmony. Ian, I will turn it over to you, and let's get started.
Thank you, Ben. My name is Harmony Taylor. I'm a partner in the Charlotte office. With me is Ian Roberts, an attorney in our South Carolina office. Ian and I are happy to be here with you today, representing counsel in both North and South Carolina. Ian's also licensed in Tennessee, in case there's any Tennessee communities who've ever been involved in the community with there as well. We are excited to talk to you about this topic today, which is something that boards would not have been discussing at all 20 years ago. Now, of course, everyone, it seems, uses social media in some way. And so this is an opportunity for us to talk about the pros and cons of using social media in your community and largely pitfalls to avoid. I can tell you as attorneys, we cringe a little bit when we hear that our community associations are actively engaging in social media other than in very minor ways, because there are so many ways that communities can get sideways. And that includes things that the boards may post, committees may post, and of course, owners. Owners and members being those we can't control, but inevitably tend to react to the actions of the board. Ian and I are going to be going through 10 rules of community association usage of social media, the pitfalls you should avoid, and best practices. We hope this is helpful to steer you into using this in an effective way for your community, and hopefully avoiding the need for me or Ian to represent you in a lawsuit going forward. We would be happy to do so and happy to charge you a lot of money to do it, but we would prefer to be providing you with substantive, helpful services as opposed to reacting, of course, to something that happened. So I'm going to start our PowerPoint. We're going to again go through 10 rules and best practices we think will be helpful. If you want to share any questions or comments in the chat feature, we'll have time to address those at the end. And we hope that this serves as some helpful information for you going forward. All right, will somebody give me Ian, am I doing it? All right. Okay, you'd think after 2 years of COVID, we'd all be a little bit better at this on Zoom, but it's still a little bit of a work in progress. So, go back to our first slide here. We're using the Iron Man himself as our format for discussing the different rules. Everyone knows that Robert Downey Jr. has had his ups and downs with social media, and he is an excellent example of the various things you should and should not do when you're using that format. Just to be clear that when we're going through this, most of the law that is in play affects North and South Carolina equally. If there are any nuances there, we will break out and talk about that a little bit. We have some different backgrounds that we bring to this, Ian and I. I did 15 years as a litigation attorney, so that's always in the back of my mind. How is this going to look if I'm standing in a courtroom? And Ian brings the somewhat unique aspect of having been a community association manager. So he knows firsthand how boards have dealt with these issues and what to do and not to do in North and South Carolina. All right, our first lesson, of course, is image is everything. And how do you want to be perceived? Everyone knows that a picture is worth 1,000 words and probably a video 1,000,000. Whatever you do as an association plays out in the image of that community. And this can be very important when it comes to things such as the desirability of a given neighborhood and whether or not someone would want to purchase property and even property values. When you think about a community's image, that includes things such as the photographs that you would have up on a website, having attractive visuals as opposed to shoddily done community photos, having a well-designed website that might have information freely accessible and paint your community in the best light, signage that's up in the community. All of that goes towards the image that you have as a community. But it's not just these websites where you get to choose how you're seen. Your image also includes things that other people are going to say about you and put out in the general world. That includes things such as this letter I have on the left, which is actually an excerpt from something sent complaining about me and other management and attorney individuals in North Carolina, and then some wider publications that had been made as part of a bill to allegedly dissolve community associations. These are publications that can be sent out on Nextdoor, sent out to media in different ways, and all of these play into an association's image. We can control what's on the community association website. We can't control what others are going to put out about the community. But what the association absolutely can do to go toward promoting that best image is how to react to it. I counsel boards frequently about the fact that just because someone says something on Nextdoor or Facebook does not mean that the association has to react to it. And it's that reactivity that we can control as communities. We can't control what someone else is going to have to put out and the complaints they're going to make. Just remember that not every missive has to be answered. Just because you get an email or see that post doesn't mean you have to hit the reply button. And if you really feel like you need to say something, maybe that's a good time to go open up a blank email, type out what you'd like to say, and then save that for later viewing and consideration. Because once we get away from this, our attractive image of the community that we've put out, positive information, substantive and factual, and try to delve into this, that's where the associations tend to lose control. So clearly, remember, image is everything. Focus on maintaining that good, positive image and not sinking to the lowest common denominator.
Thank you, Harmony. If you wouldn't mind, can you just go back one slide real quick? I do want to just briefly touch on this bottom right corner little blurb, the one with the two black boxes on there. Before we get to the meat of all of our presentation here and how associations should go about handling and running with their social media practices, I want to tell a little bit of a quick horror story. As Harmony mentioned, I was a community association manager before I became an attorney. And this little blurb down here at the bottom, where this gentleman deemed himself king of the association, said he was going to tar and feather all the homeowners who dissented, mentioned that there's now no rules, but he's just going to find people if need be. Well, it's pretty clear this was probably done in jest. This particular association in Florida, they have a rule down there where covenants will expire after a certain period of time. And in order to keep them accurate and to keep them enforceable, covenants need to be basically renewed or revitalized. This is a perfect example of what bad things can happen with associations, because this particular association's Facebook page was covered in posts like this, and the covenants ended up not being revitalized. Now the homeowners have excess taxes because the county now runs the association. It's just a lot of bad things can happen if social media is not handled properly. So the first and arguably most important step of how we can address things like this is, Harmony, if you would go to the next slide for me, is to create a social media policy. One of the most important things about creating a social media policy is that you want to make sure that it's clear and understandable to all the members of the association. these kind of policies can typically be done via board resolutions, sometimes through the bylaws. Obviously, it may depend on specific language within the governing documents, but as majority of the time it's done via board resolution, that's really convenient because it allows for flexibility in the rules. And as I'm sure everyone on this call knows, social media changes daily. Every day I get on my phone and there's some new app or there's some new feature on these apps that we're all trying to learn with. And by doing a resolution rather than having to go through an amendment or anything like that, as you would with the governing documents, it really allows you to kind of stay with the times and make sure that at all times your social media policy is proper, in place, and ready to go. So on the screen now, we have some minimums of what a social media policy per association should have. First thing is it should definitely define and limit who has access to these sites. We don't want an association Facebook page or an association website to be available to every single person in the world. Once you put something into the internet, it's very, very hard, if not impossible, to ever get it out. So things like Facebook for social media or Nextdoor, as Harmony mentioned, they have those features where you can make those groups private and make sure that you can monitor who's going in and out of those groups and who's members of them. And for Facebook and for websites, while you can't make a website itself completely private, you can make portions of it like accessible only with a username or password. Another thing that policy will definitely want to include is controlling who can speak on these platforms. One of the best ways to kind of monitor this is to usually designate a certain group. Maybe it's a committee, maybe it's the board of directors, to be the ones who are actually doing the posting on these platforms, putting stuff on the website, making posts on the Facebook groups. Having a small number of people who can actually post or make these additions to these platforms is a lot easier to control and monitor than it is if it's a willy-nilly, anybody can kind of go in there and put a post up.
Ian, I'll just comment on there too, as sometimes when we are engaging in social media discussions, we'll have members who come in and begin to object that they're not enjoying full freedom of speech. There is no freedom of speech in a community association. That's a protection for individuals with public speak in a federal context, and it doesn't have anything to do with an association website. You all have absolutely the right to restrict who gets to speak on your own platform. I will say on the Facebook page, sometimes it's difficult to truly administer that, which is why we prefer that the association use an association platform that it can control or one that your management company is administering.
Absolutely. And in addition to monitoring who can post, who can have access to sending this information out, another item that you definitely want to have on a policy is basically standards of what can and cannot be posted. We, of course, want to prohibit any negative or disparaging comments about people or about companies. There's several ways that items like that can be monitored. Some examples that the association could consider is to have a policy where any post that gets submitted to be posted on, the Facebook page has to be signed off on multiple board members. That way you don't have one board member going rogue and posting anything they want. And you also can monitor what any homeowner wants to put on there as well. Another prohibited action you probably would want to put on there is you, of course, don't want to share any confidential information or potentially embarrassing information, because that always opens up the association to potential liability. Some kinds of information or examples of information like that you want to avoid ever having posted is, you never want to post a delinquent list. Even if the governing documents say that you can put a list of people's names of who's delinquent in their assessments for the year, we definitely would not advise and definitely would say do not do that, because you're going to run into all kinds of issues, one with embarrassment, but two, fair debt collection issues as well. Another kind of example of items that the association may want to prohibit is you don't want to put anything on these social media sites, these websites, that's going to put the association into a bad light, kind of like Harmony mentioned in lesson 1 there. For example, if the association is having a party, maybe they want to restrict that no photos can be posted of people holding alcohol or doing, ridiculous things, because one, puts a bad light on the association, and two, it could also be deemed embarrassing by the person who maybe didn't know that picture was being taken or didn't want that picture shared with everybody. Another important item that you want to have in any social media policy is the enforcement policy. If any of these rules, some of those prohibited acts that we just talked about, are violated or get posted, even though they have these particular standards of what's allowed to be approved and posted to everybody, the association wants to maintain that they can remove those posts and should remove those posts as soon as possible. And also maybe restrict that particular owner's ability to post things anymore, because you don't want to have any of these negative comments consistently going on there, because while it may not have been said directly by the association or a board member, it's on their platform, and therefore the association could be open up to liability for any of those comments or anything that came about because of them. And that also goes with the screening content, as we talked about earlier, how if a post gets sent in, maybe have a committee or the board or a group of individuals who will review those potential posts or potential items to be added to ensure that they do follow the standards that are very clear and understandable inside the association social policy.
Before we go to the next screen and Ian talks about an example of a social media policy, I will point out that these various requirements for social media policies can be onerous. We all know they can be difficult, and finding individuals who are willing to screen your content before it's posted, of course, can be difficult. That should give the association cause to stop and think, do we want to undertake this? If we don't have the individuals who are willing to staff this, do we actually want to take this on as something we do and have an up-to-date social media site in some way, as opposed to simply a website that gives out necessary information from time to time? And I think one of the big reasons that most communities, especially smaller ones without an on-site manager or someone else who's able to dedicate a significant amount of time to this, are not going to have those sites, is because it does create a lot of work. And we all know that those people who have chosen to take their time out of a busy Thursday to watch this presentation are not necessarily going to have the time to take this on. If you're not able to get individuals to volunteer to assist, then maybe it's just not time to do this yet, and you would wait to jump into this more substantively when you do have that support, because you're all working hard, and unless one of you is really willing to dedicate yourselves to this, and not just one person, multiple, it can become really difficult.
Now, as Harmony mentioned, we're going to look at a very bare bones example of a potential social media policy that an association could implement to regulate kind of what gets posted and everything regarding social media websites and whatnot. I'm going to point out some key provisions that you'll see on here that's going to be based off a lot of the information we discussed on the prior slide. But as you can see here, on bullet point number 2, this is a board of directors resolution putting in place a social media policy on the association. One great point they have on here to make sure that there's no argument from the homeowners or that no homeowners are afraid that those who are running it don't know what they're doing. There's training that association board members or committees can go through to make sure and monitor that social media use is being done properly. It also has on here that it will either be the committee or the board of directors. Also allows them to put kind of a reins on whoever it is that is reviewing this material. As you see on the final bullet here, makes the social media committee members report to the board at least once every month, talking about it, going through and discussing how this whole social media is going about in the association. Is it something that, as Harmony mentioned, the association wants to keep up with and keep going? Or is it something that maybe it's time to kind of put to bed and avoid all the issues that may be coming about it? And it also, as we've talked about several times, has the screening requirement where it's going to have the board and the social media committee are going to review and discuss any posts before they get posted, giving everybody kind of a final check before something gets sent out to the association. On the second part of this example here, we talk about let me show here. Yep. Sorry, I just had my screen freeze there for a second. What we're going to talk about here is we have, this is the use of social media by owners. As we talked about on the last slide, who has access to the Facebook group? Who has access to Nextdoor or the community's website? We want to make sure that it is, in fact, strictly community members. We don't want outside people in there. We don't want family members, because obviously you're going to get biased opinions at times if you have family members involved and stuff like that. So you want to keep it very clear and concise. members get admitted into groups, members get their username and passwords, and if you share that information or allow somebody who's not in the association to get in there, it's going to be deemed a violation of this policy, which could lead to, the potential for your post to A, be removed, or B, you lose access to ever being able to post information on any of these platforms again. Again, it's got here on the third bullet point, all kinds of information that for most people would think it is common sense that you wouldn't want to be sharing on an association website, but some people are different. You never know what may get shared. Just some easy examples. Obviously, you don't want pornography, legal information, spam messages, nothing discriminatory, or copyrighted material. Basically, everything that you're going to want posted on any of these platforms is stuff that involves the association. You don't want outside information that has nothing to do with topics. You don't want a bunch of just back and forth yelling at each other and calling each other out in the neighborhood. The whole point of these things is to, as Harmony mentioned earlier in the presentation, to put the association in its best light. So you're going to want to make sure that it's just information that everybody needs to know, or information that puts the association in the best possible view of all the people who get to see this information. And in fact, this one's got another section where the board and the social media committee can, in their sole discretion, remove any of this inappropriate information or information that would be violating this particular policy.
And just to comment on that before we flip to the next slide, not only does the association reserve that right, but again, the association is going to have an obligation to do that. Because if we control or administer a site and fail to remove this information or data that comes out in a prompt manner, that is going to subject the association to liability. For example, I get on my association's website and I post something about how Ian hasn't paid his dues in a long time and some action should be taken against him. If the association allows that to stay up for 3 or 4 days or a week and then comes in and removes it, then the association has moved out of a role of simply having the website and into having some liability for not removing that, which is difficult. And some of the posts that someone would put up are obviously inappropriate, but sometimes there's veiled racist or sexist or otherwise objectionable language. Sometimes someone has posted photographs from a pool of people's children that they would object to after the fact. So there are just a lot of nuances in there, and we have to be very careful with changing mores on this. There are things that people may think are funny or are simply an off-color comment that are not going to be appropriate anymore and could open the association up to liability. So going back to what Ian said, we want to share information with the membership, and we want to paint the association in the best light for the betterment of everyone there. This is not an opportunity for people to vent their personal feelings, talk about political causes, anything like that.
And this final page of the social media policy example here may seem like it's very similar to a lot of the points that were made in the last couple of slides here, but I even have a particular note written for myself: reiterate, that posts can be removed if they do not follow or if they violate this social media policy. And in addition, there's other enforcement action that the association can and should, and as Harmony mentioned, has a duty to enact on homeowners, depending on obviously the allowability of some of their governing documents. But such actions as fines, maybe legal action if it gets too extreme to the point where it's drastically causing an issue in the association. And of course, as we mentioned, removal of posts or access to posting on social media platforms.
Right. And when it comes to removing information that may be on a website, we don't have to proceed in the same way we would for other enforcement actions in an association. We're not necessarily going to need a hearing and a fine process. The association can immediately remove the objectionable material and later address whether or not it would need to be reinstated. Always err on the side of prompt removal. The third lesson we're going to talk about is don't post copyrighted material that you do not own. I was not aware of this situation until Ian put together this presentation. This is an interesting story about Robert Downey Jr. sued by, it looks like, an author who had written some materials and books about a particular cult, I guess it was. And Robert Downey Jr. has been using that in a podcast, which I now absolutely want to listen to. And so there's legal action related to that. This may seem like a no-brainer here, but community associations frequently do use copyrighted material. And I think sometimes there's sort of misunderstanding about the difference between a copyright and a trademark and other legal protections. But generally, material that belongs is copyright means that under the federal law that an original work of authorship, which can be writing, which can be art, any sort of artistic presentation, is automatically protected and doesn't have to have an actual copyright filed with the Trademark and Copyright Office. And this includes pictures, graphics, music, sound recordings, etc. I know community associations have gotten in trouble in the past for having movie nights and showing copyrighted movies. Also in the past for having someone host a Zumba class in the clubhouse and then finding out later that the materials being used, the Zumba presentation or the music, were all copyrighted and nothing had been paid. There are attorneys and groups who go around doing nothing but seeking out those violations, going to open mic nights and trying to find artists using copyrighted songs and pursuing that. So when the association is working on its own website, it's important to make sure that it is using original information, photographs, graphics, etc., or items that have been specifically said that they are open for public and free use. There are protections for certain usage of items out in the public media that can be used for art, sometimes for criticism, for scholarship research, or for educational purposes. When we're putting together our PowerPoints for different presentations, we generally can use a lot of what we come across on the web because we're using it for educational purposes and we're not charging for that. But it's something to be careful about whenever you're going out and using these items. The community association may be a nonprofit corporation, but it may, if it's downloading photographs taken by someone else of something within the community, that could still be a violation of copyright. I've even had people get upset when the association took photographs they had taken in the community and they were managers and putting that on the association website saying, you didn't have my permission to do this and use it. Of course, you wonder where they got it in the first place, but it comes down to, we want to be careful and make sure that anything we're using, really, we do have permission to use and we're not being asked after the fact to take it down. So when in doubt, don't use it without appropriate permission. We know that frequently people will make threats about suit and say they're going to pursue the association if it doesn't take something down. Take it down and worry about it later at whether or not we want to put it back. It's unlikely you'll be sued, but you don't want to spend money with an attorney trying to fight over the picture of the clubhouse or the pool. Go ahead and get your own picture. iPhone 13 takes a lovely photo and you don't need to download this from someone else.
It was very convenient and cool, the fact that Robert Downey Jr.'s lawsuit came out the week that we were doing this presentation on social media. I thought it was pretty interesting. And I, too, am very interested to listen to the podcast if it works. I will say the individual who was suing him actually used to be an attorney who represented people who did actions or got in trouble because of cult-related behavior or said they were brainwashed or whatnot. So Robert Downey Jr. may have a little bit of an uphill climb here, but we'll see. Lesson number 4 here we have is, of course, do strictly control access and use. That it's, especially with the advancements in some social media today, it's usually pretty simple to be able to at least restrict who's accessing certain information and who's posting certain information. Our social media platforms like Facebook have privacy settings where you can make the groups private. You can restrict who has the ability to post, who has the ability to review and approve posts before they actually get sent to everybody. Another way that the association could handle this is to require that the homeowner sign a social media agreement stating that they've read the policy, they understand what can be deemed a violation and what is allowed and what's not allowed to be shared on social media platforms or on the association websites. And then, of course, we talked about restricting posts. It's a very good idea to have a committee or a group of individuals who review and take a look at these posts before they're just sent out. As we talked about, once something's sent out there, everybody in there everybody and their best friends are going to sit there and screenshot on their phone. So even if you removed it 3 seconds later, it's very likely somebody's going to have a copy of that somewhere. So it's very important. You want to make sure that before anything actually gets posted or sent out, that it's been reviewed and is appropriate and in line with the potential policy that the association will put in place. And then, of course, websites, if you have confidential or private information, you could have usernames, passwords that are only given out to specific members, and not specific members, sorry, only given out to homeowners within the association and aren't just distributed to anybody who wants to come in and get some information.
Yeah. And to that end, don't use your social media site as a place to put even hidden confidential information somewhere that's accessible via password only. I had a community that had a website like this, and then with extremely minor hacking, individuals were able to get into the board of directors section only, which contained the private confidential information of everyone who owed money to the association, including routing numbers to their bank accounts. So this is not where you put that information. Your management company has that information heavily encrypted and protected. Maybe you have the acumen to do that on your website, but I doubt it for most people. And so that really, if you have a social media site, it needs to be for social media, not for these other uses. And go ahead and keep that information separate so there's never any chance of discovery there. The next lesson, of course, is keep it clean. And Ian went over this before, talking about your policy. It's about removing defamatory, racist, offensive, violent, or illegal discriminatory material. This has become incredibly important in recent years with some changes to fair housing law. And as many of you probably know, the Fair Housing Administration said community associations can now be potentially responsible for owner-to-owner harassment or owner-to-owner discrimination based on one of the protected categories, which includes race, sex, national origin, disability. So if someone is on the social media site and they are using bigoted language, for example, and that's not promptly removed, the association then has an additional responsibility potentially for that discrimination and taking action against it. We don't want to be a party to those cases, and we want to be absolutely careful that no one is using our social media sites in order to engage in any of this inappropriate behavior. So that goes back to that same idea of being able to promptly remove information that shouldn't be there. Just generally, defamation is a false statement about someone that communicated to third parties that causes injury to that reputation. The important element there, of course, is that it's false. And often people get on social media and they make snap judgment comments. They make statements of opinion that are not stated as an opinion, but are really stated as a factual decision. All of us have seen comments on Nextdoor or in emails accusing board members, for example, of theft. That's a big deal when the treasurer is being accused of theft and they work at Bank of America in compliance, or for anyone else. But these can have very significant impacts on individuals and their jobs. If you have a contractor and people are making comments that contractor is stealing money and not doing quality work, and in fact has had multiple lawsuits against them where they were found to have committed gross negligence or something like that. These are comments that can be made very quickly, but if the association is providing a platform for that, then the association potentially becomes responsible for libel, which would be written miscommunications in this manner, or slander or oral claims. And although the truth is always a defense, it's difficult to prove the truth sometimes. So we don't want to get into fighting over whether or not the board treasurer absconded with $3. We would prefer not having those opinions about someone's qualifications and what they've done on those sites. And I jumped ahead a little bit, but talking about the fair housing laws, we really do have a significant new liability that the federal courts have not resolved as to when and how an association can be responsible for owner-to-owner commentary on actions. And of course, the association is responsible for its own actions. So in the context of social media, comments that are made in that platform can create that liability. Some examples of that can come up when the community is being described. For example, if it says it's a mature community, that may make individuals think that This is only for older individuals, although housing for older people is protected. But you want to be careful if we're talking about age, and it makes it seem like we're discriminating against younger people, families with children, etc. If it talks about an adult-only community, that again goes to possible discrimination against families with children. Traditional values can seem to be posing the community against different cultures coming in, exclusive, independent, even active. If you put that in there, perhaps that is seen as being potentially discriminatory against individuals with disabilities. We want to focus on positive comments and not the particular attributes of any individuals there. If it sounds like we are being nitpicky about this, we absolutely are, but we want to avoid these issues coming up later. And remember, if someone comes to an association and brings up an issue and says, we really object to this particular language, don't draw a line in the sand. It's far better to say, you're right, we'd like to change this, and go ahead and tweak it. Because just as you can remove comments that were made by owners, you can remove your own comments. If you have second thoughts and decide there's a better way to communicate, go ahead and do that. And don't worry so much that somehow making a corrective action is going to make it look like the association did something they shouldn't have. It's better to go ahead and just jump on it.
And I just wanted to make a couple additional points regarding defamation there. Of course, as already mentioned, defamation is typically a false statement that injures a person's reputation. There, of course, have to prove that there was some sort of injury to their reputation or whatnot. But especially in South Carolina, there are certain posts or certain statements that can be made that the proof of the damages, the proof of the injury, no longer has to be done. These actions are deemed so detrimental to a person's reputation that automatically the court is going to agree that they are in fact defamatory, or they are in fact causing damage to a person's reputation. So that's why it's so important to make sure that we're monitoring what gets posted on these platforms, because items such as adultery, or if someone accuses somebody of committing a crime of moral turpitude or has a loathsome disease, all that kind of information, stuff like that, those will be deemed by the court to be automatically detrimental to somebody's reputation, and they won't even have to prove technically that their reputation was actually damaged or not. This next lesson we've got here, lesson 6, is kind of along the same lines of just the discrimination that Harmony was just speaking about. But you don't want to discriminate in removing posts. Of course, we want to make sure that any posts that violate the policies or that are just not posted you want to have posted on these kind of platforms are removed, but you don't want to just single out a certain individual. You don't want to remove one person's post when somebody else may have posted something very similar before and that one was left there. So you want to be very careful to monitor and check and see that any kind of posts that may be a violation are in fact removed. And that just protects the association as well from avoiding any kind of selective or unequal enforcement on other homeowners. One more point I'd like to make out about that one is I've noticed this in my time as a manager, that say the board member is the admins of the Facebook group and they're the ones who have control on everything. It's very easy to accidentally like a post as the association because that's the group that you're underneath. And you don't want to be looked at as endorsing something from somebody that may be contrary to other members in the association. In fact, board members should stay away from liking other people's posts and stuff like that. There's not really any law on that kind of issue right now, but that is definitely something that I have seen pop up as a manager, where it now looks like the association is endorsing this particular homeowner, while maybe these 20 over here don't agree with that, and that causes all kinds of issues within the association.
Right. And Ian, I'm sure you've seen this as well, where board members come to us and they say, but I feel like my free speech is being stifled. Why don't I get to say this? And I think you leave some of that at the door when you become a board member. You are putting on a hat saying that you agree to speak on behalf of your community. This does mean that you can't speak in the exact same way. And that's just part of the service that you provide. But it also serves to elevate the directors. It's almost in a slight way like judges. Judges have to be careful when they're outside of a courtroom because there's a particular respect for their position. I understand that board members perhaps are not held in that same high regard, but it is something to aspire to try to take the higher ground at all times when you're speaking on behalf of the association. The next lesson is make sure that your insurance coverage covers defamation for social media. This is a quick check. Because you're all here and you're with a professional management company, they make sure that you have the coverage you need to cover most acts. But sometimes this can get lost in the shuffle there, and there'll be a policy issued that somehow will not have the rider that will cover defamation. It varies from state to state what those riders look like, but you want to make sure that there are a couple of things that your policy covers to the extent it can. I'm not an expert on this, but if you can, you want your policy to cover mold, and you definitely want it to cover social media and defamation if at all you can. Same thing for discrimination. That is often a separate rider, and you want to make sure that if the directors and officers liability policy has coverage, it has that discrimination policy that goes hand in hand with social media and defamation. There, it's usually not expensive to make sure you have it, but it's an important element. And if you choose to try to cut corners somewhere, don't do it there. Get rid of the petunias at the front, but keep that coverage because there is such an opportunity for liability there.
Next, of course, we don't want to share or release confidential or private information to an entire association and all of its members. These platforms, these websites, these social media platforms are designed to, they should be used in order to, as we've said several times now, paint the association in its best light. Confidential and private information is confidential and private for a reason. We don't want to be sharing, homeowners' particular addresses, social security numbers, license plate numbers, etc. But also legal matters. The board of directors is usually the ones who has to be involved in any kind of legal disputes that the association may be going through, and that information needs to remain private, as we'll get to a little bit later here about attorney-client privilege. Additionally, if there's any kind of legal matters that maybe a homeowner is going through, that's not information that you want to share out to everybody. That's their private information, and that's not something that's supposed to be divulged to everybody. In order to state a claim for a violation of a constitutional right of privacy, the person arguing their right to privacy was violated has to prove that they have a 1, legally protected privacy interest, 2, a reasonable expectation of privacy, and 3, that the action was a serious invasion of the privacy interest. This is very big, especially when it comes to associations. Of course, if somebody's out in the open, their expectation of privacy may not be as extreme or as relevant or prevalent as typically can be. But you have homes in these associations, and a lot of privacy rights come about when a homeowner is within their own house or within their own yard. So it's something that definitely needs to be kept in mind when you're reviewing posts or if you're making posts on any of these platforms. Some activities that have been found to violate privacy rights are intrusion into private matters, kind of like we talked about earlier, whether it's a legal matter somebody's going through or any kind of issue someone's going through that is their own personal information. Public disclosure of private facts, that would be sharing any of that information to all of the homeowners or the entirety of the association. Placing a person in a false light or misappropriation of a person's name or likeness. I've seen, as a manager, I've seen posts where board presidents' head have been pasted on, the body of the devil and stuff like that. I mean, just nasty things that just don't have no business being on an association owned and or operated platform. This Marino v. Hanford Sentinel case is another big reason why this kind of information wants to be kept in-house and not shared to everybody. Basically what happened in this case was there was a college student in California who just did not like her hometown. So she posted on her MySpace at that time. So this was back in 2009 before Facebook really hit it off. She posted on her MySpace account basically an article that she wrote about how she hated her hometown. That article ended up getting posted in the local city's newspaper, and her family, who still lived there, received a bunch of death threats. Their family business was shut down because nobody would go to it anymore. They sued, arguing that their right to privacy was violated when this article was published in the local newspaper. And the court found that because it was posted on the MySpace page, that, oh well, we're sorry, that there's no violation here. So once something's, as we said, once something's put out there, it's very hard to bring it back. So make sure you're watching what you're allowing and what you're actually posting on these platforms. As I mentioned before, attorney-client privilege. This is, of course, actual relationship with an attorney, not just I ran into an attorney down the street and just kind of gave him a question. But if the association has a real relationship with an attorney for a legal matter, and they've had communications with them, that's stuff that they want to keep in-house. You don't want to distribute to every homeowner in the neighborhood or in the association, because doing so can remove or basically extinguish that privilege that the association has. And once it's extinguished, that information is out there. And that can make legal matters even more difficult and terrible than they already are sometimes to go through. Basically, it seems easier, and I've had a lot of board members tell me it would be easier just to share all this information with homeowners. And while it may seem easier at times, it can definitely cause the association to be opened up to liability and can cause all kinds of messes within associations. So just keep in mind that while the information may be pertaining to the association, not everybody has the right to see everything.
All right, lesson number 9, because we're attorneys, we have to include something about this. Do include a disclaimer. How many times have you seen that little disclaimer at the bottom of any medication commercial or any legal ad? Of course, it's really important that you share very clearly with the membership what the rules and regulations are for usage of any social media platform, and at the same time include a disclaimer about liability if someone misuses that. The goal, of course, of social media is to include an open exchange of information, but to also make it clear that if you're allowing others to post, the views being posted don't necessarily reflect the interests of the association or the particular opinion, and also make it clear what your policies are. They won't necessarily prevent a lawsuit, but they certainly can help in your defense, and they go to the evidence showing that the association gave people advance notice of the various rules and regulations for the usage of the site and what would happen if they failed to follow those rules. These are examples of various lawsuits that have been filed. These make the news because they do come out in such a substantial way. Almost all lawsuits that are filed in the US are resolved through settlement. Many are dismissed, many go away, but every lawsuit has a significant cost to an association, not just in the actual financial cost of the association through attorney fees, but the time and energy that are sapped away from other things that you need to be focused on, and instead you're spending it on litigation. Remember that social media, can promote your community and keep owners informed, increase visibility, but the guidelines are there because we want to prevent these lawsuits in the first place. Before we go into some of the takeaways that I'm going to ask Ian to talk about, one other issue that hasn't come up that I've been dealing with a lot lately is whether or not it's appropriate to post images from, example, the pool or other common areas where there is a crime that's been committed. And that happens every year in pool season. We see people breaking and entering overnight or late at night, going in and using facilities, sometimes vandalizing, breaking things, or leaving trash. And communities come to us and they say, can we share these images with other people and send them out? And even last week, I got a request, can we post this on our social media site for help in identifying it? There are 2 answers to that. One, what can you do, and one, what you should do. Of course, in a common area like the pool, particularly where you have it posted that it's under surveillance, there's no expectation of privacy. So individuals who are videoed there do so at their own risk, and they don't have the right to protect this information. But there's a difference between sending it out and with a quote saying, who are these hoodlums who have caused this damage to the association and done this, this, and this, and sending it out and saying, can you help us identify these individuals? Not all attorneys agree on this. I have no problem in saying, can you help us identify these individuals? But as an association, I think we need to be very careful in saying why we're trying to identify them. Do people know? Of course they do, but we're not saying it. And that's where we get into the issue of possible defamation, because it's possible that we have the wrong person. It's possible that someone we've misidentified. We would just use that in order to get the information. I also don't think that that should be posted on social media. That needs to go out separately to the membership so that we can deal with that in a very discreet manner and not have it up there posted for any sort of long period of time in order to give people an opportunity to enter into various suppositions about what they think that meant or not.
Yes, and just some takeaways as we've gone through this presentation here. First and foremost, image is key. Everybody wants a great image. I'm sure Robert Downey Jr. himself prefers the right version of this picture as opposed to the left version of this picture. Making sure that you have a good image out there is key, especially when it comes to an association where people may be buying or selling houses. That being said, running a website, running social media platforms gives the association the ability to essentially craft your own perception. You have the final say, essentially, of what people are going to see and think of your association. And that's why monitoring and making sure everything is in order and that the best light is put forward is so important. One of the key ways to make sure that that image is protected is to create that social media policy that we discussed earlier, and include standards such as not stealing content, making sure those who have access and those who post on these platforms are doing so appropriately and are doing so in an approved manner that follows the policy that's very clearly and understandably lays out what should be done. Make sure it's clean, and in the event something does get through or gets posted on there that is in violation of the policy or should not be on there, make sure it's gone. Have somebody make sure that they're monitoring, keep up with it. Don't let these things sit out there, because as we've talked about, the longer they're out there, the longer or the easier it is for someone to sit there and screenshot something and have it for the rest of time. Make sure that your insurance covers social media. In the event that something does get missed and it keeps going, you want to make sure that there is some coverage there. Of course, do not discriminate. Private is private. You don't want to share information that's confidential or private. Disclaim. And other than that, have fun.
And on that note, we think it's a great idea for you to continue to have your social media policies. So Ben, are you going to share some questions with us?
We do have a couple of questions that have come in, so I will start asking. So what if a homeowner creates an unofficial Facebook page? Can the HOA be held liable for the content found on the site?
This has happened to me more times than I can think. Generally, no. The association should look at the site and see if there is any ability to object to the name. For example, if it is a particular, the exact legal name of an association, the association can send a letter to the administrator of the site and say, we're asking that you remove this. This is not affiliated with the association. But other than that, most communities are not going to want to get into any sort of fight with Facebook demanding that it come down. It's not going to be worth it. In those situations, sometimes a single communication to the person who's running that saying, this is not official, we want to make that clear, and sending a communication to the membership saying, please understand, we know there's another website that's been set up. Owners are free to create a website, but this is not an official website of the association. In that circumstance, I feel very confident that the association is reasonably protected from liability. And if things go wrong there, then that is not going to be a legal responsibility of the association. Of course, it impacts image, and that's something that we must take the steps we can to control. And that's just to continue to encourage owners to use the appropriate site and to put what pressure we can to get people to come back into a more appropriate communication.
So with social media, as board members change and an old board member is no longer on the board, but they are reluctant to give up control of the Facebook Nextdoor site that may have, how do you encourage old board members to give up control if they're no longer on the board for an official website?
There's a lot of negotiation that goes on in these matters. It always surprises me that someone would want to hold control that carefully of something. I think we just continue to make it clear that boards come and go, but the association remains. And if the website is set up for the association, that belongs to the association. I'm caging here because we all know that if someone pushes back aggressively, most communities are not going to want to spend $20,000 or $30,000 to engage in a lawsuit to get control of that. A letter that goes out to the person from an attorney can often be helpful in getting them to push that forward and get them to do the right thing. But we don't threaten what we are not willing to do and what the board's not willing to do. So there is a limit of leverage to that. I think it's, again, that communication. If the person continues to administer the site, you're going to have to migrate to a new site, and it would be a good idea to set it up so that in the future, the access is given to the board at large that can collectively change that access if they need to.
Okay, in one of the earlier slides, I think you talked a little bit about training. Who would be responsible for doing that training?
So when it comes to training on social media, of course, social media still, as it's expanding and becoming this cluster of this massive platform that it is nowadays, there are numerous, what are they called? Numerous manuals and resources that can be used. Or we can do situations like this. Maybe the board retains an attorney to come in and give a kind of a spiel like this and give some information on social media just to make sure they're following everything correctly. It also is not a bad idea to have any policy that is created reviewed by an attorney prior to it being put into place.
I'll say in most circumstances, boards should rely on their managers. Managers deal with this all the time. And we as council can get involved if we need to, but your managers know what they're talking about. When they tell you not to do this or to do that, that's usually pretty good advice. And often when we get involved, we're just saying what the manager already said. So most managers can provide some really good feedback on that.
So this is maybe outside social media a little bit, but how do you preserve privacy matters in board meeting minutes and actions taken against homeowners?
I think that probably is outside the scope of this presentation, but as a general matter, those matters should be discussed in a closed session and kept in closed session minutes that would then not become part of the regular minutes. That's how we make sure those stay separate and continue to remind board members, particularly new ones, of the confidentiality.
Right. And the same, and along the same lines of that's also where legal matters that the association may be going through would be discussed, executive sessions for the board, and those meetings wouldn't be.
And I'd have to look back on some of our webinars, but I do think in one of our earlier webinars, we did all about board meetings, and executive sessions was one of those topics. So
I think you have.
So I'm wondering if you have exposed, have you exposed your firm to any possible litigation by using the images of Robert Downey Jr.?
We don't think so. We think it's fair use of these things. We're not making any money off this presentation. It's for educational purposes,
right,
and we're big fans.
Okay. A question about disseminating the PowerPoint. We do record the sessions, and this will be on the camsmgt.com website, so you can visit that and see the whole session if you would like. And then yeah, we can certainly discuss with Harmony and Ian about distributing the PowerPoint. Next question, should the ARC post notice that they will be performing walkthroughs through the neighborhood?
I think that would depend. Usually we do not recommend that because for a number of reasons. I have personally seen board members and ARC members get accosted on such walkthroughs. I'm on my own ARC and I don't want to post when I'll be looking at different things. ARC presentations are private between the homeowners involved and the board or the ARC. So I don't know why that would be posted.
Okay. If a homeowner slanders a contractor to the HOA board or on social media, is the board responsible at all?
Probably not. Unless it was posted on a website and the association continued to allow it. Now, of course, someone can say their own opinions, such as company ABC came in my home and I thought the work they did was terrible. But and that happens all the time within. That is not slander, and leaving that up is an opinion matter. But the community needs to decide, are we providing a platform for that, or are we going to shunt that out to next door where you can kvetch about them all you want?
Okay, and this may be a similar question, but what about when a board member is being slandered on a private social media site?
Ian, what do you think about that?
So if a private homeowner is slandering a board member on their own private website, that's unfortunately not an association matter. That would be something between that board member and that particular homeowner. The homeowner may be open up to liability from that homeowner or from that board member themselves. But as long as it's not on an association platform, the association, it shouldn't have any liability.
I'll say I get requests for cease and desist letters like that all the time. And in almost every circumstance, I attempt to talk the parties out of pursuing that. It's just fuel on the fire. And people inevitably feel when action is taken against them that somehow means there's merit to their claims. In almost every circumstance, ignoring the person, even if it takes a while, completely ignoring them is the way to go and is going to get you a lot more bang for your buck. It's not as satisfactory as sending a letter telling them that they're completely full of it, but it gets you the result you want, which is if they're ignored, they're eventually going to go away in almost every circumstance.
And correct me if I'm wrong, but with libel and slander cases, don't you have to prove damages that occurred, or is that?
So that depends. Ian can talk about South Carolina law, and sometimes there are automatic damages, and there are certain things, crimes of moral turpitude. If someone is accused of those things, there are automatic damages. If you accused a board member, for example, of sexual crimes against a child, that could result in automatic penalties and automatic damages because it was disseminated.
And in particular to South Carolina, there's actually 3 kinds of damages that may be assessed in a defamation case if it is found to be that somebody was defamed. They have general damages, which is for such things as hurt feelings, essentially, damage to reputation, stuff that you can't put a monetary value on. Then of course you have special damages where if it is something that can actually be measured, maybe somebody said that a particular member of the board or a member of the association was horrific at his job and posted that everywhere, and he lost a lot of business. You can calculate those particular numbers. Then of course you have punitive damages as well, which is essentially used for 3 purposes, and that's to punish the person who defamed somebody, deter it from ever happening again, and compensating the victim.
Okay, so back to the question about old board members controlling websites that they probably shouldn't. If an old board member has a page that they've been using and they're putting things up in the community, but it's confusing the community, any recommendations on getting control or asking him to take that down?
You should ask that they take it down and communicate with the membership. You can send something out saying, unfortunately, this website is up. We're not able to force it that it be removed, but this is the official website. And then create a new one called the official Harmony Taylor's Community Association website. Have it be very, very clear. Does it seem petty and unnecessary? Absolutely, but sometimes it's still needed.
Okay, and this last question I think is around the similar topic, and it has to do with non-owners on the association page. By having non-owners involved, can that make the board liable for anything as it relates to the association? I'm reading through, it's a long post.
I don't think involving non-owners it's not advisable. It doesn't change the responsibilities here. But a resident may be very invested in a community, but they don't have an ownership interest. And until they do, they should not be part of the private entity's communications.
And kind of like Harmony mentioned in her answer to the last question as well, if this Facebook group only has an admin that's a previous board member, no other board members are involved, it's not a bad idea to start a new one, make a new official board regulated or committee regulated social media platform, and then distribute that to the owners, letting them know that this is the real one now. Whatever gets put on this one is not the opinion of the association.
Okay, another question came in, but on a private homeowner run Facebook page, when residents spread false HOA information, are there any actions that the HOA can take to have those individuals removed?
No, there's virtually none. If the comments that were being made on that site were so egregious that they did give rise to a legal claim, and it has to be pretty bad in order for us to ever recommend that someone pursue legal action, because it's so expensive and recovery is unknown, then some action can be taken. But Ian and I both spend a lot of time counseling boards that you have to have a thick skin. The best way to not be offended by what you see on these websites is to not go on them. And it's very easy to delete the Facebook app and just don't look at it. And if you do that for a week, you'll find that your interest in the issue has gone down substantially. People can complain about you in private all they want, but if you divorce yourself from that, understand that people like me who read Nextdoor and see all of these complaints that come out, we're amused, but no one thinks it's legitimate. People really don't think that this is true. And if you get concerned that they start to think that the board's doing something wrong, is not handling finances well, or they have a terrible manager, send out a self-serving communication saying, actually, here's where we are financially, and don't even address the social media. Say, we wanted to provide an update with you. We've been working with our great manager to get our budget in line. And for the first time, we have our contracts all in place, and we think the budget's going to come in under budget, and we're going to not have an increase. Send out your own positive information. Going back to that idea of the image, that's what we want to focus on, not the naysayers, because they'll always be there. Every community is going to have a certain percentage of people who want to complain about something. But instead of engaging that, let's focus on the positives that your community is doing, because you're all doing a huge amount of work. Let people know that so that they don't have a void of information that's filled by complaints.
And we see social media cause issues, every single day. I mean, you turn on the news, someone's got themselves in trouble with something they did on social media. Responding directly or acknowledging comments like that on private Facebook pages is doing nothing but adding fuel to the fire. Like Harmony said, sometimes the best action is just to completely ignore it and let the fire burn out.
Yeah, I mean, I'll just leave it with, there's one particular homeowner in North Carolina who has contacted my entire family on social media to tell them what a terrible person I am. And I just ignored it and she stopped. It will eventually happen, but it can take you have to have a thick skin, and some people are not as heartless as I am, but try to remind yourself that this too shall pass.
Okay. Well, thank you very much, Harmony and Ian. Great information. Thank you, everybody that's still with us today. As a reminder, we do post these videos on our website at camsmgt.com under the board member resources page. So we hope to see you next month, and third Thursday of every month. So we do thank you.
Thank you, Ben, Susan, for the opportunity. Thanks.
Absolutely. Good night.
Thank you all.